So yeah, so I know Mr. Bell. I know him well. So I'll talk to him.
So you're going to call him and tell him that I've been arrested?
I'll let him know that you've been arrested.
Newly released body camera of the moment police confront a teacher about her having sexual contact with a student that she was teaching at a juvie facility. We also have the newly released letters that she sent this teen, including ones where she was accused of talking about having that student kill her husband. We're on the case, presented by Law and Crime. I'm Chris Stewart. We're getting some interesting access to an investigation that just wrapped up in Kentucky. I'm going to show you letters, handwritten letters, that a teacher who was married and a mom sent a murder suspect in a juvenile detention facility that were explicit in nature and even had lines that had prosecutors arguing that she wanted that student who was in the juvenile detention facility to take out a hit on her husband. Prosecutors in tiny Adair County, Kentucky argued that 27 Elena Bardin tried to have this student allegedly kill her husband. We'll talk about how the verdict played out in this case in just a moment. Now, before we get into the body camera video and I show you those shocking letters, let's break this down. Elena was a teacher in the public school system, and she was assigned to help young people spending time at a local juvenile detention facility. Now, that, of course, is admirable work. It takes a special type of person to be a teacher and to help people who have been struggling in life. And it appears that she also lived a very admirable life at home. She was a loving wife. She posted videos on TikTok of date night with her husband. She's also a mom, and she made sure that people knew how much she loved her daughter. You can see in this post that she says, quote, "my girl." It was posted on March 27th of this year. But it was in that month that staff at this juvenile detention center found these letters that were left for an inmate serving time in connection to a murder in Louisville, Kentucky. Now, we have dozens of pages of explicit messages, and several, I'll tell you, are just too graphic to show you here. This is one that is between Bardin and that student, where she talks about oral sex with the boy and having sex in his cell, and she finishes the note by saying, quote, "I hope you enjoyed that. I know I did." She also says, "I love you, and I'd like to run into your arms, but that might be odd, LOL." Now, on top of the letters, prosecutors presented explicit pictures that Bardin sent this boy. They say that she got them developed at a local Walmart. They also have security camera footage showing her going into the boy's cell, even though that is not allowed per facility rules. But not only did Bardin sexually abuse this teenager, she also made statements in the letters that had prosecutors arguing that she wanted to put a hit out on her husband, a man who, at least on social media, she did seem to love, a man who was the father of her daughter. Yet in this letter, she says, quote, "Okay, call me effed up, but if you want, I thought you were talking about putting a hit on my husband. I can't give you my ring. I gotta make it look like and make him feel like we're good, but I won't wear it around you. Don't be mad at me. That makes me sad." She also wrote in another letter, quote, "This was honestly the most time spent with my, quote, husband in a long time. We had a good day, but it really solidified for me why the two of us just don't work. I just really effing missed you all damn day." Now, when it comes to building a case, these letters are without a doubt incredibly damning against Bardin. She writes in one letter, quote, "You know my child is my #1 priority, but the way you love and talk about redacted name, that makes me now doubt that you're an amazing father. I don't think I have to go into the sex part of it because you and I both know that is the cherry on top." End quote. Now, clearly Bardin, as the teacher, is taking advantage of this teenager, but on top of that, on multiple occasions, prosecutors say she brought up the idea of a hit on her husband. I typed Elena Bardin's name into truthfinder.com, and as you can see here, the charges that she was convicted of came up. Truthfinder will be able to show you the background, even the criminal background of people who you are searching for. We use Truthfinder all the time here at Law and Crime because it helps us understand the people who are involved in our stories. But even if you don't work in true crime, it can be a great resource because it's one of the largest public record search services in the United States. And with the paid subscription service, you get access to unlimited reports about almost anyone. And right now, you can get 50% off your first month of confidential background reports. Just go to truthfinder.com/OTC. In this letter, she says, quote, I know you say you'll take care of him, but shouldn't someone else do it so the suspicion is miles away from you? IDK, I'm going to miss you so effing bad tonight. You look so handsome today, love. I love you. She also once wrote, quote, you're out of your mind for talking about poisoning my husband. And she says, I get nervous when, the line's cut off here, come home and someone has killed him. So it seems like she's talking about what it would allegedly be like if her husband was killed. Now, with the letters and security video showing Bardin going into the boy's cell, police had evidence to confront Bardin with what they had. Here is body cam video of her being arrested. And when I watched this for the first time, what stood out to me was Bardin's cool and calm demeanor, as if being arrested is not that big of a deal. Take a watch.
So I'll talk to him.
So you're going to call him and tell him that I've been arrested?
I'll let him know that you've been arrested.
Sure.
And then obviously you need to reach out to him from the jail, okay?
Okay.
And then just, again, he knows me, I know him.
Mm-hmm.
You can just
Will
tell
his number be there? The jail don't have it. Like I have a card in my car.
Okay, I'll get it. How much you need? Where's it?
I just like right next to my phone.
Just get it.
Okay. I don't want to get something out of my vehicle.
Is this okay? She asked for her Bible.
Yeah, that's fine.
You let him hold that joint?
Hey, your mom's got, hey, your mom's good with taking the car, right? Your parents are good with taking the car, right?
Us taking the car?
Yeah, when we're done with it, we're going to turn it over to you guys. We just want to make sure you got a driver and stuff like that.
Yeah. Thank you.
You can put those up.
So we're done with this. I
Yep.
can put it back in my car.
Yeah. Yep.
Thank you.
Yep.
Got anything on you? You're drawing?
Yeah. I just got my attorney's card in my pocket.
I'll be here. We're just gonna get this one right here. Before I can get you in there, I'm gonna patch it in real quick, okay?
Okay.
And I guess there's stuff in here.
Now, Bardin doesn't seem to say much, but you can see that she is very calm. She's seemingly not too shocked that she was being arrested. She already had a lawyer on hand, so it's unclear if she knew this arrest was coming. Here is when she gets out of the cruiser at the county jail. The officer reads her that her husband has filed a protective order against her.
You getting me out right here?
Yeah, we're at the jail.
Okay.
Let's get your glasses. Just go to the top of the ramp for me.
Yes, he just now walked through the door. So,
Have a seat here.
just a few minutes, okay? Okay, thank you.
Now, the rest of that video is redacted. In all, prosecutors say Bardin and the boy exchanged roughly 140 pages of letters, many sent by her talking about sexual fantasies with this underage boy. Bardin learned her fate last month in a trial that lasted 2 days, and it returned a shocking verdict. Bardin was found guilty on 1 count of first-degree sexual abuse and a count of unlawful transaction with a minor and distribution of obscene material to a minor. But on the count of trying to get a boy in a juvenile facility to kill her husband, jurors found her not guilty, perhaps buying the argument that part of her communication with the boy in these letters that you just read, it was all just a joke. The Times-Leader newspaper writes that Bardin's defense attorney said, again, all of this was a joke, that it wasn't serious, that she actually wanted someone to kill her husband. And he said that these letters about killing Bardin's husband were never actually taken seriously. The newspaper did say that the juvenile testified and told jurors that he thought Bardin was serious about killing her husband, but he never planned to actually do anything about it. Her attorney also told the boy that he was grooming her as much as she was grooming him, reportedly. Bardin is expected to get prison time. It's unclear how much she will get, but if she did actually want her marriage to end, the Times-Leader writes that her husband filed for divorce in May, and he also filed custody for their daughter. As for a prison sentence, prosecutors are asking for a sentence of up to 14 years. This former teacher, now former wife, soon to be inmate, is slated for sentencing in November. I previously spoke with criminal defense attorney John Day about this case. All right, joining us now to talk a little bit more about this is criminal defense attorney John Day. Thank you as always for taking the time to be with us here on Law and Crime. So they have the messages that she allegedly sent saying that she wanted this juvenile to kill her husband, but she's found not guilty. What do you make of that?
Thanks for having me, Chris. So this is an unusual one because the prosecution would not have brought this case unless they had a good faith belief that they had more than enough to convince a jury beyond a reasonable doubt that she was trying to hire someone, in this case, this minor, to kill her husband. So what we see is that the jury was very thoughtful. They deliberated on this and were able to toss out some of the charges based on the testimony they heard. She still was convicted of felonies, but the main case against her brought by these prosecutors failed.
And it seems like from what I've read that the defense's approach to the messages about allegedly wanting to get this minor who's behind bars in this juvenile detention facility to get him or one of his friends to go and take out her husband to get out of this marriage. And the defense seemed to be she was never actually serious about that. How effective is that argument, the I was just kidding argument, in cases like this where you might have a piece of evidence like a note or something like that saying where someone actually wanted to do it?
Right. Well, I mean, in this case, it was effective, and the defense team was able to convince the jury that they shouldn't take it seriously. And of course, that's a blow to the prosecution. But again, remember, they were able to determine that in their eyes, she was guilty of, crimes of dishonesty, crimes that involve things like sending the material to the minor's involvement with the minor. So the jury was able to at least make some kind of distinction there. But the idea at the end of the day that the defense can say, look, don't take this seriously. She's just sort of, this is a humorous exchange between the defendant working at the facility and then these juvenile inmates, the juvenile people, the kids in detention. I mean, that must have been very effective in the eyes of the jury, because even though they were able to convict her, they still had doubt. They still had a belief that what the defense was saying was accurate. And remember, she did not testify, and they apparently didn't call any other witnesses. So this was solely based on picking apart the prosecution's case.
Because to your point here's someone who, there's evidence that she had crossed every sort of ethical line and legal line when it came to having sexual contact with a minor. She's sending these notes. There was like 140 pages. And I did note in the newspaper that I guess even the detective was blushing when he was reading these messages that she was sending the boy because they were that explicit. It appears that they had some sort of motive, they believe, that she wanted out of her marriage, but not to split the assets, not have to share custody of their daughter. So it seemed like in a lot of cases that this is typically where it gets a guilty verdict. In cases like this, though, where you see kind of this split decision, what type of jury typically goes in? Like, what does that say about this group of people that they saw that? And how common is it to actually see a jury be able to kind of distinguish what she's charged from here and what she's actually guilty of here?
Yeah, it's an interesting point, Chris. And I'm thinking back to the maybe 1,000 jury trials that I've done in my career. And every single time, what I notice, and it's always the same. A jury is they take their job seriously. Okay, you may not like the outcome, whether you're a prosecutor or defense attorney, but the jurors are, this is their job. They're brought together. These are 12 people or 6 people or however many it is who don't know each other, and they're brought together. And they're given this task, they're given this assignment to sit there and listen to this evidence. A lot of times it's incredibly disturbing. And so you've got situations where people who are strangers to each other sit in a little room, they're watching video, they're hearing disturbing testimony, they're looking over at a defendant sitting at the defense table. At the end of the day, they take their job seriously. And a lot of times I've disagreed with their verdicts, but I've never thought that the jurors in my cases didn't take their job seriously. In this case, in this Kentucky case, what we see is a jury that did take their job seriously. They sat down there and they were able to pick apart the case that the prosecution threw at them and said, okay, we believe parts of this, we don't believe other parts of this. And even though the facts here are incredibly disturbing, involving allegations of involvement with a minor at the juvenile detention facility, they were able to say to the prosecutors, basically, you didn't have it. You didn't prove it to us. And we took our job seriously, and we looked at the evidence, and we were able to acquit her of some serious charges.
So the timeline for this, from investigation to a verdict, seemed very quick because it was in March of this year, end of March, that they discovered these explicit materials. Then 4 days later, it's April 2025, she's arrested, and then here we are, it's a 2-day trial in September to determine whether or not she's guilty. That feels quick. What do you make of that timeline?
Yeah, it's quick. I mean, jurisdictions differ in terms of what their caseloads look like, but this does particularly seem like a quick track for the prosecution's case. And then, of course, the jury didn't take them too long to come back. I mean, they had some idea going into it what they wanted to do, obviously listening to the evidence. But it was probably my guess, from having had these types of cases before in situations with jurors, they probably went into deliberations having some skepticism, at least, about the prosecution's case, because they were able to pick that apart and say, we're going to acquit her of these charges. So as the evidence is being presented, as the case is unfolding, they're being skeptical.
And this trial lasted just 2 days, which I think for some of the high-profile stories that we're often talking about, these are trials that go on for a long time. Brian Kohberger would have been 3 months. Sean Diddy Combs, that was determined to be a pretty long trial as well, far more than just 2 days. Very different situations, and I get that. But what goes into determining how long a trial is actually going to go, and in this case, just 2 days?
Yeah, well, both sides make an estimate for the judge. Prosecution looks at how many witnesses they have, what the type of testimony is. Is there a lot of, video? Is there a lot of photographs? And this, is there a lot of, in cases involving things like homicide, of course, you're going to have lots of autopsy reports and photographs. And this particular case was probably streamlined, it seems like, because it was, from the prosecution standpoint, it was relatively straightforward. Not a lot of expert testimony, for example. That takes up a lot of time when both sides have battling expert witnesses who are testifying. The prosecution put together what they must have thought was a streamlined case. But given the verdict, you wonder, did they shortchange their office? Did they really have it together? Because when you go up and you lose on counts like this, when it's the most serious charges, you've got to go back and wonder, what did we do wrong?
What is on the prosecution side, and even for the defense in your work too, when it comes to determining, okay, here's the evidence we have and this is what we need to get? Because maybe in hindsight they're looking and saying, was there a witness that we could have brought? I know that they had the juvenile himself on the stand, and I'm sure they felt really good about him as a witness. The text message, or not the text messages, the letters, they had a diary from her as well, surveillance video of her going in, and that certainly made a strong case on the sexual counts that she was facing. But what is the strategy typically when it comes to making sure that you're telling a story that is one that can keep jurors engaged and not boring them, but also not shortchanging them of important facts?
Right. Well, you kind of hit on the key factor. I mean, if you're a trial lawyer doing criminal law, whether you're on the prosecution side or the defense side, you've got to be a storyteller. I mean, the best lawyers I've ever seen in court are also the best storytellers, and they're the ones who have been able to whether it comes naturally or whether it's something you've worked on for years, you're able to put together a narrative in a way that a jury can follow it, can understand it, and can believe it. And at the end of the day, they can accept your version of events. So if you are, we see this a lot in younger lawyers, younger prosecutors, defense lawyers. They don't have maybe storytelling skills that they will develop down the road in their career. But that kind of stuff, jurors are used to things like watching lawyer shows on television and in the movies, and they see these streamlined presentations that are, polished and eloquent, and they go in there expecting that. They expect that. Sorry, I have a dog here, Chris. Apologize.
All good.
So the jurors go in there and they expect a streamlined presentation. They expect that the lawyers are going to be like the guys they see and the women they see on TV. The problem is it takes a while to get that to that level, even if you're not on TV.
Yeah, because I'm sure even in cases, I even think back to Casey Anthony and like Jose Baez, like a showman, someone who was just very good at telling her story, and then you saw the verdict go in their direction. You think that that's the expectation even in a rural county that someone might have, like Adair County, where all of this took place. I know prosecutors are asking for 14 years for her sentence on these 2 other counts that she was found guilty of. And even though solicitation for murder, not guilty, the idea that she had sexual contact with this boy and was, passing along explicit messages, very, very serious charges. What typically goes into a judge's decision in a case like this about whether or not she could get and I know every jurisdiction is a little different, but generally speaking, what a judge will look at to determine what that sentence will actually be?
Right. Well, remember, the judge has sat through the trial. The judge has been able to evaluate the defendant's honesty and character in that little window of a trial, even if it's a 2-day trial where they're watching them. Even though the defendant doesn't testify, the judge has the evidence that the prosecution presented, and the judge has been able to watch the demeanor of the defendant at the defense table. That's one thing that I think a lot of times is overlooked is when you're in court at a trial, it's like you're putting on a play if you're the defense lawyer, and you have to tell your client, everybody's watching you throughout the entire thing. So even on a break, even when nothing's happening, eyes are on you. So, but the judge is going to consider criminal history. The judge is going to consider the nature of the offense, the person's own history. In this case, because she was in a position of authority, I think a judge is going to be much more severe in sentencing than if it was a different situation. Because when you're given that authority, for example, in her position teaching, a judge is going to say you abused that, and so there's a penalty that's going to be stronger than what otherwise I would be giving.
Even though she was found not guilty on the solicitation for murder charge, there was evidence that she made comments that she wanted her husband dead, even though the defense said it was a joke. You had the juvenile on the stand saying that he at least thought she was serious. Reportedly, he said that, even though he felt like he was never going to go through with it and never actually gave it serious thought. Could that, even though she was found guilty, factor into a judge's decision about, well, she still said some pretty disturbing things, at least, about her husband to a witness that testified at this trial?
Yes, absolutely. The statements of the witnesses are going to be sitting in the judge's mind as the judge is making the sentencing determination. Judges are surprised sometimes by a jury's verdict, and in their minds they can sort of adjust the punishment to fit what they think really happened. Judges accept the jury's verdict, obviously, but at the same time they've sat through the evidence, they've heard the testimony. And, I've had cases where judges are frustrated that the prosecution couldn't close the deal and convince a jury. And so there might be some effort by a judge to say, look, I know how serious this is. And even though you weren't convicted of this, I know what I heard. And so you do see that from time to time. Obviously, a judge is going to want to apply what they saw during that trial. Even if it's 2 days, they heard plenty of evidence. So again, I think it's going to come back to the person's history, their position in the community, their position of authority. And is this an aberration, or is this something that this person has had a history of, behavior that's not appropriate? In this case, we don't know that. But at the same time, the fact that she was in a facility in a position of authority is going to obviously have an effect.
And I wasn't obviously in the courtroom for when the verdict was read, but I'm sure for that top charge, there was a moment of relief for the defendant that she wasn't guilty of that most serious charge, but then the wave comes for you're still convicted of these 2 other charges, and you could spend some serious time, 14 years maybe. That's a good chunk of your life in prison. I mean, what are the emotions like on the defense's side? Where I'm sure as that lawyer, you're thrilled that you, like, I mean, it seems like some pretty good lawyering that went on during the trial, but at the same time, your client's still going away for a while. I mean, what's the emotion and the dynamic after that happens, the conversation with the defendant? Like, take us inside the room for that.
Right. Well, as a defense lawyer, you try your best to prepare your client for the worst case scenario. I mean, you say, look, you know, the trial's over. You have some time with them after the jury goes to deliberate. You're waiting on the verdict, and you go through all the scenarios with your client. I mean, you've done this beforehand, but it really hits home when you're waiting on a verdict. You tell them, you know, here's the possibility. Here's what looked good for us. Here's what didn't look good for us. You know, be prepared for the worst case scenario. And the best lawyers are able to prepare their clients for that eventuality. I mean, you look back at the O.J. Simpson trial, and you know that his lawyers told him, you know, there's a real serious chance that you're going to be convicted here. And so when the verdict comes back and it's less than what the prosecution wanted, it's not, in this case, it wasn't a full acquittal, but the defense has got to be pleased with being able to get an acquittal on the most serious charge. And the client, the defendant, of course, is going to be relieved. They're still facing time, but it's not nearly as much as they would have been. So there's a sense of relief, even though it's very likely that they're going to do some prison time.
And then just lastly, you know that the prosecution and what they may present asking for 14 years. When she's sentenced in November, what can the defense do to try and limit the damage and the amount of time that she'll spend in prison?
The defense from now until the sentencing date is going to be focused on mitigating her sentence, providing information to the judge about her, who she is, what's her background, what led her to this place, what is there that that the judge ought to consider in showing some leniency. I mean, you put together a whole book on your client. You get family history, you get social history, medical history, work history. You talk to friends, you talk to neighbors. I mean, to do a really good job on a sentencing like this, you've got to have an entire, essentially a book about your client, about the defendant, to give to the judge to say, look, this is who she is, this is how she got here. She made a mistake. She hasn't made any mistakes like this previously, if that's the case. You basically are building a story about your client, about the defendant, that has to be based on facts, obviously, but you want the judge to look at it and say, here are a lot of reasons not to max her out. Here are a lot of reasons not to give her the maximum sentence.
And we'll see how it all plays out. I know she's going to be sentenced in November. Shocking verdict to see that not guilty come across, but of course she'll likely spend a good amount of time in prison. John Day, criminal defense attorney, thanks for breaking this down for us. It's always great to have you on Law and Crime.
Good to see you. Thank you, Chris.
That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.